Court of Appeal in the 4th and 5th District of the State of Florida is now in session. The Honorable Scott Maycar, Judge, presiding. All persons having business before the court draw near, give attention and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Well, good morning, everyone, to the 5th District. We have on our agenda this morning 3 cases. We're going to go straight through the 3 cases without a break. I don't know whether the marshals had time to get the allocation of time for the parties. I think there's cross appeals in both of the first 2 cases. So has there been time reserved for the rebuttal and cross rebuttal? Please approach.
We have not discussed that, Your Honor.
Okay.
How to address it now?
Sure, absolutely. Well, we've got 20 minutes per side, correct? So would you like to reserve time for rebuttal?
I would.
And how much?
10 minutes.
Okay. And on the cross appeal?
I'm going to reserve 2 minutes, Your Honor, on the cross appeal.
Okay. 10 and 2. As the marshal, you have that?
Yes, Judge.
Okay, great. Thank you. All right. Well, with that division of time, we will go ahead with the first of our cases here. It's Rosenberg versus Rosenberg, 23-1079. You may proceed, Mr. Tanner.
Good morning, Your Honors. Mike Tanner for the appellant cross-appellee, Nancy Rosenberg. May it please the court. On the issues in the main appeal, there are 3 key points that we would ask you to bear in mind as you look at this issue. The first is that we submit there really can be no dispute on this record that the husband's expert witness calculated the personal goodwill of all 35 physicians in the medical practice, and then took that figure, that aggregate figure, and deducted it from the equity value of the practice. And only after he did that did he apply the husband's percentage interest in the practice to that net number, arriving at the marital interest of the husband.
Can I ask a quick question
Yes, sir.
To clarify? You're not contesting that there was a goodwill, personal goodwill, associated with all the other physicians?
Correct.
And you're not contesting the amount of the goodwill?
Correct.
Overall? And I don't know to what extent this is in the record, but whether that overall goodwill was divided between 35 people or not. I think it was. It sounds like it was equally, rather than attributed.
That was his testimony, the expert.
Right. So you're not contesting the overall amount of goodwill or the amount of goodwill as to each physician, only that the calculation should have, in your view, only taken out the one physician's, one
That's correct, Your Honor.
Dr. Rosenberg's.
Yes.
Okay.
That's exactly right. And that one adjustment you just referred to, we laid out in our brief at pages 18 and 19, and the expert, we believe, did a very good job in his approach and his calculation. We have no quarrel with his model other than that one point. And you can very easily, from the expert's model and his calculations, go back and make that adjustment. And we think that would be, the adjustment would be consistent with Thompson and all the other cases that talk about personal goodwill. And I will say this, as we said in our brief, the court in Thompson said only the personal goodwill of the marital litigant is deductible in arriving at the marital interest. And so you can follow that, that sort of bright line rule. But we also say if you look at the basic economics of what is in the record here, the personal goodwill of those other doctors could not be, by definition, personal goodwill of the husband, because personal goodwill is, in Thompson and many other cases that we cited, derived from the skill, reputation, or continued participation of the individual.
But what, I think the expert made some statement that caught my eye, something to the effect that how could your client be entitled to the goodwill of these other physicians when the spouses of those physicians wouldn't even be entitled to it?
Because as to each of those physicians, the value created by the work of all the other physicians is nothing more than enterprise goodwill. Because if you think about it, we know from the record here, from the expert, that the husband worked at only no more than 5, and predominantly 2 of the surgical facilities. There were 18 of them where all the 35 doctors worked. All of that revenue from all 35 physicians generated at those 18 facilities went into creating the value of the enterprise. But the husband, we know, could not have been, none of that value at those other facilities where he didn't work could derive from his skill or reputation or participation because he never worked there. And so for him, it was no different than if he had sold a share of Coca-Cola or General Motors. He was simply an equity interest in an ongoing corporate enterprise where value was generated by the others. And I understand that you picked up on that rhetorical question, Judge, that the expert asked in his testimony. Well, he was a little confounded with what to do with this personal goodwill value of the other physicians. And we think the answer to that is obvious under Thompson.
Well, Thompson, was that just a one
It was.
physician rather than multiple physician
It was.
case? So I haven't been able to find it. Is there a case out there that says what
No.
should be done when there's multiple physicians?
I wish there were. I mean, you're precisely right. All of the cases, really, that deal with this issue deal with a single individual, be a dentist or a doctor or a lawyer or someone, where the value of the enterprise is very much tied up in that one individual's continued participation. But here, I mean, this was a $100 million enterprise, and each of these physicians had a 2.86% interest in it, and they each generated, though, depending on the math, I think the expert calculated somewhere around 3%. Each one of them generated about 3% of the revenue for the enterprise, and therefore about 3%, maybe a little less, of the value. But it's unquestionable that in the transaction they received a payment for their percentage share of all that other value that they had no involvement in creating. So that's our position. It's simply the equity, the enterprise value of the medical practice that the husband received.
So, Mr. Tanner, if I
Yes,
could
sir.
just ask a follow-up question to a question I think Judge Makar was getting at as well, but just so that I understand, you are saying that, and you referenced it in answering the question, that your client gets the benefit of the enterprise goodwill, which what I think is akin to just the value of the business, excluding the value that the appellee brings to value to the business.
That's absolutely correct.
Okay, but so even though that, if we, as a follow-up to what Judge Makar was saying, even that enterprise goodwill can be broken down as to individually all of the doctors that make up the practice as well. They each have their own personal goodwill, which is used to sum up the enterprise goodwill.
I would say that's right, Your Honor.
So that's also speculative as well. But what you're saying, even though you said the appellee didn't practice in these other remote locations, you still get the benefit of the practice in the other locations to the exclusion of the appellee. The appellee doesn't get that benefit.
Well, the appellee does get the benefit of it. The only difference is the personal goodwill of the effort of all the other doctors goes into the marital interest, which the appellee would share 50-50 with the appellant.
Okay, I think I understand. Yes.
So we, in summary, kind of back to your point, Judge Makar, the one adjustment that we think that can be made and should be made is in the alternative calculation that we laid out at pages 18 and 19 of the brief, and it's a very simple calculation. You just add back in the personal goodwill, which the expert calculated, and we don't contest, add that back into the equity value, subtract out then the personal goodwill only of the husband, and then divide that number by 35, and you arrive at a marital interest. And interestingly, when you do that calculation, the husband's expert and the wife's expert, using that calculation, came to a result that was within $23,000 of each other.
Well, while you're on these alternative
Yeah.
approaches, I thought the one that they put in their brief was in there somewhere, where they said, well, another way of doing this, and really what happened in this case, is they took the $71,660,000, divided it by 35. I mean, that was the value of the enterprise divided by the 35 physicians, and that came out to be a little over $2 million.
Right.
And then they subtracted out this individual physician's goodwill, which is about $1 million.
Well, that double counts it.
But how?
I saw that. I think that double counts it. Because if you take out, if you add back in the personal goodwill of all 35 physicians, you're going to get the $71 million roughly of equity value. So then if you take that value, what is the husband's personal goodwill? What is his contribution to that $71 million? Well,
About $1 million. It's about $1 million.
it's about $1 million.
Right.
So if you take his personal goodwill out of that aggregate value, you get a value of the business that is net of his personal goodwill, and then you divide that by 35 and you get, his percentage share of that equity value that takes his personal goodwill out.
Okay. I mean, what I'm struggling with is I think when they divided 71 million by 35, that to me comes across as, well, that's about the average overall revenue attributable to this physician minus the personal goodwill equals about $1 million. That's their calculation, and it seems like that's a fairly acceptable approach as well.
Well, our position is I think that double counts it.
Okay.
And I think if you look at the formula that we did on page 18 and 19, I think that preserves, I think that takes out the value, recognizes and takes out the value contributed by the husband to the overall enterprise, and then gives the husband and the wife the marital interest of the remainder, which they share 50-50.
You're into your rebuttal time, but you've got plenty of time.
Well,
So
I'm going to stop there unless the panel has further questions on that, and we'll stand on our papers on the cross-appeal issues. I'll address them on rebuttal.
Okay, great.
Thank you.
Good morning, Your Honors. May it please the Court, I'm Michael Korn of Jacksonville. I represent the appellee cross-appellant, Dr. Rosenberg. The inherent fallacy of the former wife's position in this case is this, and it was one that was put forth by their expert at trial, which the trial judge rejected, and that is that there was one transaction. And there really was not one transaction. There was, in fact, 35 separate transactions. Each physician made a decision whether to sell his or her shares to what was then Sheridan, now called Envision. So, Judge Makar, you addressed, I think, very, very succinctly the formula that is appropriate, and it's laid out at page 41 of our brief, so you can find it relatively quickly. Because this was not a one transaction case, and if you look in the record, you'll see there's a stock purchase agreement and 35 separate counterparts where each physician signed his or her name to it. So we're really not talking about this double counting theory that counsel alluded to during his opening. And we really don't have the same type of cases that Thompson and some of its progeny have addressed. Here, we have a market. One of the struggles that trial courts especially will have in dealing with valuations of ongoing businesses or professional practices is, well, we're really kind of predicting what's going to happen in the future. Goodwill is in many respects, personal goodwill is in many ways a predictive feature of how much revenue can I reasonably expect to obtain in the future based on various factors.
Backing up just a second, your friend on the other side has told us he doesn't believe that there's a Florida case dealing with this precise question of personal goodwill in a multi-physician practice. Do you agree with that? Are we, in an area where there's really no precedent, and you're looking for us to set the law in this area, or do you think there's something that's more helpful than Thompson?
Judge Pratt, I haven't seen it. I haven't seen a case that's comparable, but again, this is not a situation. If the practice had been sold, if it had been Sheridan purchasing the NFAC practice, that might have been a different scenario. But here, as I said, there are 35 transactions. Each physician had to make the conscious decision, first, am I, in essence, monetizing my future income to get it now, to get it up front? And that was undisputed. Everyone basically acknowledged that the whole structure, the reason why these practice purchases can even take place is because the physician is cashing out early, if you will, monetizing, which was the term I think that their expert used, the income that they could expect in the future. What else did the physician have to do? The physician had to sign a new employment agreement with the new purchaser, had to sign a new non-compete, which was for 5 years with 2 additional 2-year options. And again, very significantly, and very different from other scenarios that I've seen, they had to actually, in essence, sell their admitting and practice privileges at each of the facilities where they practiced to Sheridan. Now, what was the purpose of that? Well, Judge Day, the trial judge, figured it out, and he said it during the trial. He said, well, the buyer doesn't want to buy an empty nest. He doesn't want to buy a practice where the physicians can then go across the street and theoretically practice and compete against them. So here, the non-compete was coupled with something that was even more strong, which was the idea you can't even practice in these facilities. And one thing that counsel said about the extent of Dr. Rosenberg's practice, he took call at virtually all of the facilities. He correctly stated that a focus of his practice was in certain facilities, partially because of the relationships that he had developed over the years with the surgeons. Anesthesia practices are interesting practices because they're not the standard patient-physician relationship. It's almost like appellate lawyers in a way. I was thinking about it. It's like, well, we oftentimes work for the trial lawyers.
Right. If the point is to put the patient to sleep, you don't have much patient interaction, right?
Right. And the patient who's gone to the surgeon, whether it's for ophthalmological services or cardiac or plastic surgery or whatever it is, they're basically have a relationship with the surgeon. They rely on the surgeon to say, I want you to assemble the best team, the most reliable team to get me through this successfully. And so the fact that he worked in certain places didn't mean he didn't take call at many of the other places, and the evidence was also undisputed.
If I can interrupt, I think we get it that there's personal goodwill here, and it's maybe very high, and for some physicians, lower for others. But here we have a record where it was just assumed, here's the personal goodwill. No one's challenging that calculation. It was sort of a, I won't say back of a napkin kind of determination, but it was sort of like, this is what I think it is, and then divided across all 35. What I'm struggling with is, why is what you're saying about the nature of the transaction important when we get to this decision about how to handle the personal goodwill? Because
Judge, I think what it does is it focuses and emphasizes the fact that these transactions were in fact separate and distinct, and that each physician had to make a decision whether they wanted them to upfront monetize their income or not.
I thought I read somewhere, I thought there was something where it said that no physician in his or her right mind would not go along with this because they would lose out on the overall value of the practice. Like they were sort of, not forced, but there was some sort of coercion or duress.
Well, Dr. Rosenberg testified at the remand hearing that he struggled about this, but he also recognized he had relationships not just with the surgeons that he had developed, and there was competent, substantial evidence about that, about what he had done to develop his base, but he had relationships with the other physicians in the practice. The experts, including Frank Hancock, who was the business broker who had put the deal together in the first place, even acknowledged that there was nothing that would prohibit a physician from not agreeing to sell his or her shares. As a practical matter, it could have presented some very problematic issues. But it focuses again on the idea that we're not valuing the enterprise per se. We're not using the total amount of value here as an enterprise purchase. It was really a purchase of each individual physician's interests. And that's why and ironically, if you go to the equations on page 41 of our answer brief. If you do it either way, it's commutative mathematics. If you do it either way, you get to the same number. If you took the $71,660,000, you deducted 50% goodwill. This was the formula that Ray testified to at trial. You got 35,830, and you then multiply by the 1/35, the 35 physicians, and you get the $1,023,000, which you rounded to $1 million. But if you do the same thing, you take the same number, 71,600, you first multiply it by the 35, by the 1/35. So you get, well, so what is Dr. Rosenberg's interest? His share of the net equity was $2,047,000. And then you apply the 50% goodwill. And that's how you get to the exact same number, which is the $1,023,000, which he rounded to $1 million. So if this is a tipsy coachman analysis, we get to the same number. It's just a matter of what mathematics use. It is not a double count by any stretch, and it is not violative of Thompson in any respect.
What if all the personal goodwill is in one physician's bucket, so to speak?
Well, of course, that's not the record that we have here.
Right,
The only evidence we have is what Dr. Rosenberg did to establish his practice and his work habits and his reliability.
But actually, that doesn't really matter because the overall personal goodwill was decided to be $35 million divided by 35. So it's $1 million apiece. So
well, no, the 35, respectfully, are what the 1/35 is how you get to the actual number of what's the value. Then you apply the goodwill analysis.
Right,
now,
that's in your brief at page 41.
Yes, sir.
Right, but that's not how I read it initially. I guess what I'm giving the hypothetical. Like here we have where the record establishes that all 35 physicians had the same amount of personal goodwill, right?
Well, you could argue that, but you don't need to in this instance, precisely because of the manner in which this record comes to us. Because if you just simply take the 71,660, which the other side agreed, all of the adjustments that Mr. Ray made for marketability, taxes, et cetera, were all appropriate. So that was an accepted number. And you simply say, okay, we have this amount of money. We had 35 transactions, so you divide it by 35. And then you get from that number, you say, okay, as to this physician, this is how I figured his goodwill. Now, in your hypothetical, if Dr. X were to be divorced, and I suppose there could be testimony about, well, what a percentage of his or her income could be attributable to the efforts of the enterprise versus the efforts of the individual physician. And you would have a different fact, you'd have a different case. But the analysis, the theory under which you'd be moving would be really the same thing.
Okay, well, I'm not sure I heard the answer to if it's different. I mean, if you have one physician who's a top performer, lots of personal goodwill, then you have a dud who has no personal goodwill, has a poor bedside manner. That doesn't matter here. But I'm trying. How does that work?
Well, Judge, I think you could argue that that we'll call the superstar physician could have far more than the 56%, 44% split. You could say this physician was such a star that he or she had 80 or 90% of the goodwill, but that would be dependent on the facts of that particular physician's relationship in the community, the ties that he or she had with the referring physicians and the facilities, and so that's where I think is the best answer I can give to your hypothetical, which is it would be hypothetical because you wouldn't necessarily be applying the same second factor. You know, after you divide by the 1/35, you still would then, well, you know, superstar physician versus other physician. And that's how you would distinguish it because, again, it's a separate transaction that stands on its own merits.
It seems to me if you had, let's say all 35 physicians filed for divorce at the same time, how does it work then? Does each of the spouses under this calculation get approximately $2 million, essentially taking the entire value of the practice, leaving the physicians with no personal
I think you would get to the $2 million figure and then apply the personal versus enterprise goodwill factor. And each number could be very much different depending upon the relationship of each individual physician.
Because your approach is $1 million is the net amount that your client
That was the adjusted amount that the expert opined to, yes, sir. And there's ample
And they're
evidence
saying
that
it's
supports that.
2.
I'm sorry?
They're saying it's about 2 million, or thereabouts. So 2 times 35 is 70. That's essentially the value of the entire enterprise, personal
But
entity.
valuing the entire enterprise, it's not double counting, it is undercounting for our purposes, or overcounting for the wife's purposes. Because again, this wasn't one transaction. And that to me is the essential distinction that the wife does not address or does not recognize, that each transaction stands or falls on its own. Now, as it happened, if all of them signed off, well, then that's where it goes. But
At some point, I hope both of you perhaps can comment, if you've even looked at it, and I assume you have, the second case we have, which is a very different approach. And I'm concerned because we have 2 different cases, 2 different, wildly different approaches. I shouldn't say wildly, but very significantly different approaches to this issue.
I have looked at it, Your Honor, and in fact, it was addressed in some of the motion practice in this court. But again, that comes to in some respects, comes to the hypothetical that Your Honor just addressed a few moments ago. First of all, facts are different. At what point in time are we looking? Here, the valuation date was the April 1, 2016 date, because that was the date of sale, and it was the closest to if there had been a trial, if the disclosures had been made back in January of 2016. Whereas in other cases, the divorce may have occurred a year, 2 years, 3 years into the non-compete.
Well, here the non-compete didn't play a role at all in your case, did it? In the actual calculation?
Only, not to the calculation, only to the extent that it further emphasized why personal goodwill is so significant here. But Mr. Ray's analysis was primarily focusing on the exclusivity of certain facilities and the non-exclusivity of other facilities. So, for instance, if the facility, the surgical facility, says you can only use this group for your anesthesia services, it's a far different situation than you have basically an open shop where anybody can work, and the surgeon therefore has the ability to draw upon a wider potential group of anesthesiologists, and that was, I thought, a very elegant way of Mr. Ray addressing that issue. I'm into 5 minutes. If I could, I'd like to address the cross-appeal shortly, Your Honors. When this case was returned back to the trial court, the court specifically noted, the trial court noted, that the other valuations and distributions other than the interest in the husband's net marital value of the practice would remain the same. But what ultimately happened in this case was the wife decided that a Fidelity IRA account, which had been established by the husband's father while he was in college, well before the marriage, and which was titled in her name solely for purposes of survivorship, should now be brought back into the mix, should be brought back into the marital consideration, even though there's testimony and evidence in this record prior to the first original judgment coming down, and not like a day or two, but like 10 months before that judgment came down, an email exchange, it's in the record, where the wife basically says, I know that your parents set this up, and I know the reason it was titled the way it was for survivorship purposes. He had alluded that he wanted to change the beneficiaries. He says, well, you can't do that because there's a standing order about changing status of title as to assets while the divorce was pending. It wasn't, don't do that because I've got an interest, or don't say you can change it after the divorce, but only to my one half. It was accepted as a non-marital asset before. It was adjudicated in that fashion, and then only after we're back are we now having to deal with a retrial, in essence, of this Fidelity account.
As I read the law, that's the way the law says it has to be. Is that not the case?
Well, the case was reopened, but I would submit to Your Honors that the wife still did not meet her burden, assuming that it's free for all, and I make the suggestion that she basically waived or abandoned it. If you don't accept that argument, we still have to go to what are the actual facts and circumstances here. And the only thing that the wife really tried to hang her hat on, so to speak, to justify this recalibration of a non-marital asset now becoming marital was, well, there might have been capital gains, and maybe maybe been capital losses, and maybe we took advantage of them, for tax purposes during the marriage. There's no evidence as to what those actually were. There's no number. It's totally speculative. I suggest that was not competent substantial evidence, despite the trial court referring to it in the order. And if that was the case, I was thinking, well then, if there's a non-marital account, does that mean to avoid having that account be somehow characterized as marital, parties would have to file separate tax returns so that somebody doesn't get the benefit of either a capital loss or declare income on a capital gain? I don't think that's the law either. Here, even if she did not waive, I would suggest to you that she did not meet her burden. Finally, 30 seconds on the fees. This case ran up a lot of fees, both in the first phase of the case and then in the remand phase. We understood why the trial court may have granted fees before, but here, because the final judgment originally entered had been vacated, the parties were brought back to equipoise. They were brought back to the same spot that they would have been, fighting about valuation, hiring experts, and doing all the rest. So the Rosen factors that were relied upon by the wife to get yet another fee award, 100%, with no findings as to establish the exact...
So, but the fact that the husband did not disclose the transaction sort of, had unclean hands, so to speak, doesn't that play a role?
It set the table for the initial proceedings, Your Honor, which is why we never appealed the subsequent appellate fee award after the first district had affirmed the trial court's vacating of the judgment. But what I'm saying is that the trial proceedings that we're here on today would have occurred anyway had there been full and complete disclosure of the potential transaction, for which the record shows there was not even an offer at that time. Thank you.
Thank you. And Mr. Marshall, if we could have 2 minutes total for his rebuttal, which is what he originally asked for, and we'll add 2 minutes to the appellant side.
Thank you, Your Honor.
If they would like to have those 2 minutes. Up to you.
May it please the court. I think where my colleague and I disagree fundamentally is this is not 35 separate transactions. It was one transaction. And if you look at the stock purchase agreement, yes, it required the signature of all the shareholders, but it valued the practice overall, $98,600,000. There's no separate valuation of each
Were the
individual.
terms the same for each of the
They
35
were.
doctors?
Yes, sir. They were.
There wasn't any unique condition or
No.
non-compete, or there's a continuing obligation for at least 2 years as well for the doctors to continue to practice under the umbrella of the corporation.
Yes,
Is that correct?
5 years actually.
5 years.
Yes, sir. But there was nothing unique to any individual physician. They all signed the same employment agreement over the next 5 years. So it was a corporate acquisition. Again, yes, it required the consent and the participation of all the shareholders, but there was no separate valuation. And
Just to clarify that one point, keep your thought.
yes, sir.
I'm looking at both these cases, the one after you, and I'm not sure how familiar you are with it. Same transaction, the same selling of the shares. And in the second case, the wife received, who was the physician, received $3 million. And here it was, I think it was $2 million, wasn't it?
Well, I think
So-
that is a pre-tax figure.
Okay.
And the number that we're using here in this one, because of the record here, was an after-tax.
After tax, okay, perfect, thank you.
Yep, okay. But if you consider that this was just one transaction and valued as an overall enterprise, and I think that's fairly what the documents show. The documents don't show that any individual shareholder's interest was valued separately. Then the formula that we gave you in our brief is consistent with that, and not consistent with their individualized approach that my colleague gave you. I do want to address, you mentioned the other case. I think the one key distinction between that case and this one, and I'll address just the record in this one here, the expert here testified, and we think it was a reasonable approach based on revenue, that 50% of the payments that the husband received or his personal goodwill. Now, we disagree with that for the reasons we've said. But in the other case, the expert there said that 100%, all of it, was his personal goodwill. And we submit those approaches are just fundamentally irreconcilable. And so and I'm going to get to that next one in a few minutes.
You've got time to argue in the next
Well,
case.
I won't, yeah, I won't do that now. But, here's the point I want to be clear on. Remember, there were two corporate entities here. There was the medical practice itself, where most of the value reposed. But then there was the inactive affiliate, Medibill, which was a billing service. Dr. Rosenberg's testimony was absolutely clear that that was a dormant entity and had gone out of active business at the end of 2013, and all it did was collect old receivables of the practice. So that was, and that was not disputed. I will move on then to the cross appeal, if I may, unless there are other questions on the main appeal. Sure. On the cross appeal, there was competent substantial evidence to support the trial court's decision on the fidelity account. The evidence was undisputed that the account was titled jointly in the name of the husband and the wife for more than 10 years before the petition was filed. They reported the gains and losses on the account on their joint tax returns. They paid gains or taxes on those with joint marital funds. And the husband, there was a dispute in the testimony. The husband said, "My father set it up for me alone," and the wife said, "He set it up for the two of us." It was up to the trial judge to decide, who he believed in that, and he concluded, based on that evidence, that the account should be treated as intended for both of them, and it was joint. In terms of abandoning the issue, the wife consented in the consent final judgment in 2016, based on the overall distribution of all of their assets there, that account could go to the husband. But as the trial court said, we think correctly, once that was undone by the trial court for the reasons of the husband's non-disclosure in his deposition, which the first district affirmed, once that was undone, there was no agreement. So essentially what they're arguing is, well, even though the whole agreement was undone, that one piece of it should continue to have force against the wife.
Is it a discretionary decision by the trial court? In other words, if
It
the trial
is.
said here, we're not going to replow that field. You agreed to it before. I'm not going to allow it to bring it up. And would we affirm that decision on appeal?
You did. You should. I'm sorry, did the first district?
No, I meant in this.
Oh, I'm sorry.
I'm sorry. In this case, when it comes back to the trial court from the first district, and then the issue comes up about who owns the fidelity account.
Right.
And the trial judge says, we've already plowed that ground before. I'm not going to allow, you already agreed that he could have the account. It's his account. I'm not going to allow us to reopen that absolutely as to the practice, because that was not disclosed by the husband. But could the trial judge, in his or her discretion, say, no, we're not going to replow that field. They've already done it.
He did not do that. That was their argument. That's what they wanted him to do. He declined to do that. I don't
Did he
think
have
that.
to? I guess, did he have to?
I don't think that would have been within his discretion to do that. Once the agreement was set aside, then the agreement was set aside in toto. On the issue about the legal fees, it is, as we said in our papers, the wife does have the financial resources to pay her attorney's fees. We don't dispute that. But we do say that the wife, because of the litigation positions that the husband has taken and continued to litigate right up through the motion for rehearing after the final judgment, that she really had no choice but to continue to litigate here, because in the consent judgment, the husband's expert valued the medical practice that we're talking about here that ultimately sold for $100 million, valued the husband's interest in that at $100,000.
That was going to be my question. The first go around, the practice was $100,000.
Yeah. Well, it was 122 for NFAC, and I think, I think, Judge, that might have been both the affiliates together, but it was in the range of $100,000. Obviously, that was the whole point of the proceedings, to set aside the consent judgment to enable her to then litigate and obtain the full value based on the transaction with Sheridan. And yet the husband continued right up, through the proceedings on valuation to argue for a value that used the 2014 number that was agreed to in the consent final judgment. And he argued that in their brief to the trial court after the hearing. And again, they argued that in their motion for rehearing after entry of the final judgment. So we submit, what choice did she have other than to continue to litigate that interest? So for that reason, we would ask the court to affirm on both of the issues in the cross appeal and the consolidated appeal. Unless the panel has further questions, we'll rest on our papers.
Thank you, counsel.
Thank you.
As to the cross appeal, I thought it was significant the counsel didn't address the trial counsel's comments to the trial judge once the First District had brought the case back. He said, we're here to talk about the practice. And don't worry, Judge, this is not that complicated in their view. It's a simple issue. We just got to deal with how do we calculate the actual value, net marital value to the husband. It was only later that the issue of this fidelity count came in. I would submit to you that if the wife's contention that it was substantial competent evidence that she says that he, husband's father, set this up for us years before they even met while he was in college, that's not competent substantial evidence to support her burden. And nor did she create, as I said, any basis to show what use of the gains or losses actually occurred, other than just, there were gains and losses. So I think it's significant that there was a shifting of gears during the post-appeal of one litigation. Now on the fees. At a point in time, and I alluded to this when I was here before, there's a point in time where you say, what would have had to occur had the wife known that there were possible purchases in the wind back in early 2016? The same things would have happened. And counsel's contention that, well, we litigated to the end of the earth, well, that's what parties do. They litigate cases. There were obviously substantial issues relating to the valuation that were litigated. The fact that the husband gave the court various options as far as valuation dates does not create any kind of bad faith. It's not a Rosen scenario.
So on the first go-around, she had not been given a substantial sum of money as a settlement. They were still in the midst of litigation, correct?
Well, she got a not insubstantial equitable distribution, and in fact, the distribution was such that she actually had an equalization payment because of the manner in which the assets were falling.
Okay.
And to only cherry pick this asset, to me, respectfully submit that it was almost like, I've got him down, let me see what more we can do. That's not fair, that's not equitable. To your point, Judge, would the judge have been within his discretion to say, no, I've already plowed that field? Yes, I think it was an abuse of discretion to say we're going back to that field now. Well, thank you, Your Honors, for your comments and for your attention. Thank you.
Thank you, counsel.